Important that I point out that we're now going to be talking about what happens next. So no longer talking about application or interview phase. Now we're talking about job offer phase. And things are going to change now. Things are going to get really interesting. According to the ADA, once you sort of cross this line from, I didn't have a job offer, now I've got a job offer. Things are going to change. Here we go. So the next slide has a photograph of a person smiling and holding up a mobile phone to their ear. They're sitting in a chair in an office type setting facing a computer, and there's a keyboard in front of them. So you've been given what's called conditional job offer. What happens next? Really, really big change. Disability-related questions can happen next. So now it opens the doors for employers to ask you disability-related questions. A big change from before. And also, employers are allowed to put their candidates through medical testing. They couldn't do this before, but things have changed because now the employer is giving you a job offer. It's called a conditional job offer. And get this, employers can give out more job offers than they have jobs. That surprised me, but they can do that. So it really is a screening out time of the employment process. Okay, but there are some stipulations, and they are, if an employer is going to ask disability-related questions and require medical testing of their candidates that have a conditional job offer, this must be done for all candidates of that job category. So they can't single one of the candidates out. So you're the one we're going to send for medical testing. Everyone else just kind of wait it out. It has to be for everyone. And also, the employer must inform the candidates if the results of the questions and tests will adversely affect the job placement. So you're supposed to know ahead of time going into it what the ramifications could be. Okay, next slide, please. And on this slide, we have a person facing some products on a shelf, maybe in a grocery store or drugstore, and they have both hands up as if they're arranging the products. So here's a question. Can an employer screen me out after a conditional job offer? Well, I kind of gave this one away, but the answer is yes. There are some stipulations, though, and they are. The employer must be ready to prove to folks like the EEOC, if they come down to it, that the decision that they made is not due to the disability itself, but one, that the candidate was not able to perform the essential job function with or without reasonable accommodation. And then, or the employer could say that the decision was made due to what's called a direct threat. And that's an ADA phrase, kind of like essential job functions, reasonable accommodation. There are these little catchphrases that the ADA has. Direct threat is one of them. And it basically means that the employer can prove that they completed an assessment, a pretty thorough assessment, that by placing that person in the job with or without accommodation, it would cause a safety situation, would put others at harm or put that person in harm. So, and that's it. It can't just be, an employer sat down and thought about it and said, that just sounds really unsafe. I don't think I want to hire that person. According to the ADA, it has to be a very thorough, a very thoughtful assessment that was done, not based on fears, misconceptions, and stereotypes, but on real facts, proven that, A and B would lead to C kind of a thing. So if an employer is going to use this argument, hey, EEOC, I couldn't place that person, even though I gave them a job offer, I had to rescind it because after the medical testing, it showed they had, X, Y, and Z health conditions, and we just can't have that person driving our trucks or working our forklifts, et cetera, et cetera. The EEOC is going to say, well, prove that to us, that this person really would have put others or themselves in harm's way had you placed them in that position. Okay, so that's called direct threat. Next slide. We have a photograph of a person sitting at a CCTV, a desktop CCTV. They're wearing glasses, and they have their hands on the XY table of the CCTV. So once you've accepted the job, what happens next? what happens next is you show up for work, okay? And then, if need be, you go ahead and request your reasonable accommodation. So let's talk more about that. Reasonable accommodation once you've started work. So we're going to call this the employment phase, and that's the next slide. And the slide after that, we have a photograph of 3 people in a row. They're all facing computer screens. The person in the center is smiling at the camera, has a head wrap, and is wearing a headset. So let's get into more of the reasonable accommodation request. And remember, you can make a reasonable accommodation request at any time during the employment process, not just when you've been employed, but at any time during the process. So you're going to state the problem. You're going to relate it to a medical need. And you're also going to get written verification of the need if your disability is not apparent. And this is just a review. Again, you don't have to use the words reasonable accommodation, but you can if you want to, if that's your style. So how would you phrase a reasonable accommodation? I'm going to show you 4 examples. One of them does not fit and it does not have all the elements we talked about. The first example, a person says, hey, I'm having trouble getting to work at my scheduled starting time because of medical treatments I'm undergoing. If they said that to an employer, does that sound like a reasonable accommodation request? Here's another one. I need 6 weeks off to get treatment for a back problem. How about the next one? I need a new chair because my current one is uncomfortable. And here's the last example that could or could not be a reasonable accommodation, the way it's phrased. My wheelchair doesn't fit under my desk. So the answer is the third one. I need a new chair because my current one is uncomfortable. What's wrong? What's missing out of that statement? Does it tie it to yes, the medical necessity is not there. I don't have a disability, but my chair might be uncomfortable, and I might ask my employer for a new one. That doesn't trigger ADA. That's not a reasonable accommodation request. But the others are. They may not sound like reasonable accommodations, but they have all the pieces. They talk about a problem. They relate it to a medical issue. What was the other part? Oh, just get written information. Okay, so yeah. Okay, there was a question. How are we doing on time, by the way? Do we need to reserve questions?
Yeah, we'll reserve the questions until then.
Okay, let's move on to the next slide. So limitations to reasonable accommodation. Employers have, there are limitations. And here's a photograph of a person pointing at a hearing aid, behind the ear hearing aid. And they're outside smiling. Employers don't have to provide personal use items like hearing aids, your standard eyeglasses, wheelchairs. The ADA says employers don't have to provide personal use items. They don't have to lower productivity standards for their employees with disabilities as a reasonable accommodation. They can if they want to, but they don't have to under the ADA. And they don't have to change or eliminate essential job functions to accommodate a person with a disability. They can if they want to, but they don't have to. So there's that phrase again, essential job functions. It's so key to figuring out your rights and what reasonable accommodations can look like. Next slide. Okay, so knowing that, we're going to take a look at a list of requests, and you can ask yourself, are these reasonable accommodation requests or not? And the first one is, I need new eyeglasses. Would that be a reasonable accommodation request? How about this one? My JAWS screen reader program isn't reading all of the elements of our new database program. What about this one? Even though everyone here is expected to make at least 50 phone calls a day, I'm not going to be able to because I have to take more breaks due to my disability. And here's the last example that may or may not be a reasonable accommodation. Even though I was hired to greet people as they approach our customer service counter, I can't do this because of my anxiety. Okay, in all 4 cases, an employer could accommodate the person if they wanted to. But in only one of these cases would the ADA say that's a reasonable accommodation request. And that is the second one. My JAWS screen reader program isn't reading all of the elements of our new database program. The I need new eyeglasses would fall under personal use items. Employers don't have to provide that. Reducing productivity standards is not something the ADA says an employer has to do. They can if they want to. And then changing a essential job function. I was hired to greet people as they approach our customer service counter, and I can't do that. Employers are not expected to have to change or remove essential job functions to accommodate their employees with disabilities. We'll go to the next slide. So here we have a photograph of two people in an office setting. They're on either side of a desk, and the person on the right is in a wheelchair looking down at a piece of paper. The person on the left is pointing at the piece of paper and looking down at it. So when you make a reasonable accommodation request, and it has all those elements we talked about, you trigger what's called the interactive process. This is an ADA phrase. We like to use it. So interactive process. Basically what you're doing is you're putting the employer on notice. So once the employer realizes, oh, this is an employee asking for an accommodation based on disability, now they're put on notice and the clock is ticking. So what is an interactive process? Timely meetings between the employer and the employee with the disability to determine the appropriate accommodation. And the question then becomes, well, how timely is timely? Well, the ADA doesn't say. I wish it would say, but it doesn't say. But I've asked, and the response I've gotten back from people who know the ADA better than I do is, we would expect initial contact between the two parties within 2 weeks, and 2 months is too long. So somewhere between 2 weeks and 2 months. But at least they gave me something concrete. Okay, let's go to the next slide. What if the employee or the employer, what if they don't know the right accommodation? What if they know that there's an issue, they know it's related to a disability or a medical condition, but no one knows what the accommodation should be? That could very well be the case. And here we have a photograph of a person wearing a chef's outfit in a commercial kitchen, and they're arranging food on a plate. There's lots of plates of food on this metal table in front of them. So you're at DSB right now. DSB is a great resource for information and referral to different organizations that can help identify accommodations for people with disabilities. But there's one I want to share with you, and it is called the Job Accommodation Network. They have a really robust, very comprehensive website at www.askjan.org. That's ASKJAN.org, and JAN, J-A-N, stands for Job Accommodation Network. So let's take a look at their website real quick. Next slide. I did a screenshot of one of their web pages that I like going to. So this is at askjan.org, and it's the link for accommodation search. And you'll be put on a web page called SOAR under the JAN website, Searchable Online Accommodation Resource. And there is a search field, search the database. So I typed low vision in there and I hit search. And we'll go to the next slide and see what I got back. I got back a list of links to various publications by JAN. And some of them were written relatively recently. So the first one is called Blindness, Accommodation and Compliance, Blindness, 12 November 2018. And there's one, Low Vision Accommodation and Compliance, Low Vision, 28 November 2018. So some results did come back, and you could read the different publications on this website to get an idea of different accommodations that can work for people that have that disability. Okay, we'll go to the next slide. Okay, what if you're in a situation where you do know the accommodation? Then what happens next is the employer should consider your choice. However, ultimately the employer gets to choose. And the ADA says that the employer can choose a lower cost option that is equally as effective. And on this slide we have a photograph of two people working in a factory, and they're working on discs. One person is holding the disc very close to their face. Another person is using a hand tool, and there are some clock faces on the table in front of them. Okay, let's go to the next slide. Here we go, true or false question. And the question is, during the interactive process, the employer may try out accommodations and stop them if they don't work. This would be like a trial situation. Can they do this? And the answer is yes, true. And we have a photograph of a person wearing reflective vest and glasses, smiling at the camera. There's a stack of merchandise in front of them. They're in a warehouse setting. Okay, we'll go to the next slide. Let's say the employer denies your reasonable accommodation request. What do you do at that point? Well, we would say, okay, as someone said EEOC, you could do that, but you could also find out why. Go back to the employer. It's an interactive process. You can go back to the employer and ask why. Because if the employer comes back at you and says, well, your medical information did not show that you had a disability, then you can come back to them and say, oh, okay, I can provide additional information to verify my disability. So you stay in that interactive process. What if you go back to, next slide, sorry. What if you go back to your employer has denied the reasonable accommodation request, and you ask the employer why, and they say, oh, well, that accommodation would be an undue hardship. Okay, what do they mean by undue hardship? That's an ADA phrase. It means it'd be a significant difficulty or expense to the employer to provide that accommodation. It also means it could be unduly extensive, substantial, or disruptive to the work or the business. It could mean that by providing that accommodation, it would fundamentally alter the nature or operation of the business. If that's the case, if the employer comes back at you and says, undue hardship, can't do it, it'd be too expensive, be too disruptive, we can't do that, then you're going to come back to the employer and say, I'd like to suggest another option. Or you could go to the EEOC. That's always an option for you too. And on this slide, we have a photograph of an adult with their hands up in the air outside at a playground, and there is a child swinging in a swing towards them. Okay, next slide. True or false? Transferring an employee with a disability to a new position within the company is an example of a reasonable accommodation. Is that an option for employers, to transfer an employee from one position to another as a reasonable accommodation? They can, yes, this is true. It is an option for employers. And we have a picture of a person who is pouring some pellets or seed into a bag, and there are bags of seed behind this person in a pet store. Next slide, please. So transferring an employee from one position to another as a reasonable accommodation is considered reassignment, and I call it reassignment as a last resort. So if employer and employee have tried all other options, they can consider a transfer. And if they do a transfer, the ADA says you've got to do it in this order. You've got to consider a lateral transfer first. What is a lateral transfer? That means from a position to another position of the same pay and benefits. So we're not going up the ladder, we're just going straight across. And if that doesn't pan out, if there are no positions that the individual is qualified for at that time, then the employer can consider the next option in reassignment, which is a downward transfer. And a downward transfer sounds just like that. It would be like a demotion or a move to a position of lesser pay or lesser benefits. So does the employer just have to look at what's available today? If they can't accommodate the person with a disability, do they have to look at what are the available positions today? Well, the ADA says no. The employer needs to look at jobs that are vacant today and also jobs that could be vacant as far as 6 months from today. So they really want the employer to take a look at what the possibilities are going to be to really try to retain this employee. Okay, and what's important here is that the individual must be qualified. So we're not just sticking them in any position, but a position that they're qualified for. And on this slide, we have a photograph of a person leaning and smiling on their woodshop project, looks like an end table that they're putting together with different clamps and so forth. Next slide. Okay, so someone talked about this a little bit, and I'm catching up with them now. What if the employee disagrees with the employer's decision during or after the interactive process? Then you can file a complaint. Now, the ADA says that they would recommend that you go through your chain of command, if there is one. So go to your boss's boss, et cetera, et cetera. Try that first. If that doesn't work, you may have a union you can go to try to resolve it. If that doesn't work, or if you don't have a union, the EEOC is always available to you. And there's also local agencies that are available to you. You have to file a complaint with the EEOC and get a notice to sue from the EEOC before you can start a lawsuit against the employer. And that's important. That's an important aspect of Title I. And we have a photograph of a person holding a plate of food, walking around a counter in a commercial kitchen. We'll go to the next slide. So what's it like to file an ADA complaint against a covered employer? And I put covered employer because we talked about the covered entities of the ADA. So if you're a federal employee and you want to file a complaint, you would also go to the EEOC. It's going to look a little different, but I just want to go over the specifics for an ADA complaint, which means your employer is not a federal government agency. So you can file your ADA complaint electronically with their online form. You can go to their EEOC field office and you can file the complaint in person. You can file the complaint in writing and mail in a signed letter. You can also file with what's called a Fair Employment Practice Agency. And for Washingtonians, we have what's called the Washington State Human Rights Commission. So this is what the EEOC calls their local office or local field office or Fair Employment Practice Agency. More about Washington State Human Rights Commission in a second. But I do want to say, if you're going to file a complaint against a covered employer under ADA, you have a window of opportunity to do so. So don't wait. This is one where the clock is ticking. You'll want to file sooner rather than later. And I would give myself 180 days deadline to do so. In some cases, you may have as long as 300 days, but for me, I'm going to say 180 days, so I get it done in time. Okay, and we have a photograph of a person standing in a field of crops, wearing dark tinted glasses and holding a long white cane. Next slide. So here is a screenshot of one of the web pages at the Washington State Human Rights Commission website. So if you go to their website, you can take a look at what they're going to request in terms of information from you to file the complaint. And I thought it was interesting how they worded their first paragraph. I'll just read a little bit of it to you because it has an interesting distinction. Remember, one of the covered entities under the ADA Title I is private employers with 15 or more employees. So keep that in mind as I read this. The Washington State Human Rights Commission has no jurisdiction over employers with fewer than 8 employees, Native American tribes, the federal government, claims in which the unfair action took place outside of Washington, claims in which the last date of harm occurred more than 6 months prior to the filing date of this complaint. So what's interesting about this statement is it mentions employers with 8 employees. And I told you that the ADA applies to private employers with 15 or more employees. Well, what happened is the federal ADA law says 15 or more employees. Well, the state said, we can do better than that. We're going to set the threshold lower than what the Fed set it at and require that our state-based employers practice non-discriminatory actions in their employment processes for the people of our state. So you can imagine that if Washington State, they set the number at 8 or more employees. So Washington State said, if you're a business in our state and you have 8 or more employees, we're going to hold you to the same requirements that the ADA holds employers with 15 or more employees. And then what about Oregon? So if Washington set it at 8, Oregon set it at 6, right? Idaho set it at 5. And how about Alaska? What do you think they set it at? 1. They said if you're an employer with 1 employee, we're going to hold you to all the Title I requirements of the ADA. And they can do that. And I think they should do that. Okay, that's my personal opinion. But anyway. Okay. I got the 10-minute mark. Okay. So we're getting to the end here. Next slide, we have a photograph of people wearing lab coats, walking down a long hallway, and the person on the left is using a dog guide and conversing with the 2 other people. So what happens when you file a complaint with the EEOC? In 10 days, the EEOC will send a notice to the employer. The EEOC will request mediation to result in voluntary settlement. That takes 3 months on average. Or the EEOC will investigate the charge, including employer's written answer to the charge, interviewing and gathering documents, and this can take 10 months on average. Next slide. We talked about this a little bit. When can you sue the employer? You have to wait until after you file with the EEOC and you have a notice of right to sue from them. And this can take 180 days, and then you can sue after the EEOC has completed their investigation. And on this slide, we have a photograph of a person in a recording studio with a microphone, and they're smiling at the camera wearing dark tinted glasses, and there is recording and audio equipment behind the person. So we're on to the last slide, and this is just a placeholder that again reiterates that we're Northwest ADA Center. Our 800 line is available for free technical assistance Monday through Friday, 8:30 to 4:30. It is 1-800-949-4232. You can also email us if you prefer at nwadaCTR@uw.edu. Please go to our website. We have lots of good information that can help answer your questions and clarify things about the ADA. And that is www.nwadaCenter.org. And that's it from me for now. I'll turn it over to Jeanette.
Actually, let's just pause for a bio break and then come back, and then we'll get started with Jeanette.
The microphone is on, David, so you can ask Mel.
Are we able to ask questions?
Yes.
I'm curious about what the reasonable accommodations request law or rule, how that would stand for going to school and asking schools to make accommodations.
So this is Mel, so that would not be Title I, unless you're talking about being an employee of the school, but I think you're talking about being a student of the school.
Yes, ma'am.
So that would probably fall under Title II of the ADA, which governs state and local government agencies, which schools tend to fall under. If it's a private school that's not receiving any federal funding and has no state program, then you'd probably be looking at Title III rights, which would be for public accommodation. So private schools would have responsibilities under Title III, and public schools would have responsibilities under Title II. At the end of the day, does it really matter? The question is what kinds of accommodations. They are mandated to provide accommodations to students with disabilities, very similar to what I shared with the employment cases.
Okay, awesome. Thank you very much.
You bet. And universities are an interesting animal. They have a lot of requirements, not just under ADA, but also if they receive federal funding, then they have to follow what's prescribed under the Rehab Act. There's IDEA, there's a whole list of legislation that they have to follow, laws that they have to follow, federal laws that they have to follow. So they're under a lot of scrutiny. You can certainly call the Northwest ADA Center if you have a specific question. We might be able to refer you if your school is in one of our 4 states. Just lost my train of thought. There was something else.
That's okay.
Yeah.
No, yeah,
call us.
probably calling is probably going to be my best
Yeah,
option.
hopefully you'll get someone who can answer this question a little better.
No, you did just fine. Thank you very much.
Okay, thank you.
Okay, and Jeanette's not gonna be going on until 2:15, so we have a couple of minutes for questions. I have one in the back of the room here in Seattle.
I have a question. Name is Bernie.
Can you hold, please? We're gonna take a question from the Seattle office.
You're going to do what?
Okay, a follow-up question to the previous question asked about schools, universities. I had previously had difficulty getting accommodations in the educational setting. And worked with the Disability Services Office and had a really hard time with them. And I wonder why that would be. I mean, is that I wasn't able to get what I wanted or needed?
Yeah, we have a long way to go. It's not a perfect world. There's a lot of improvement that needs to be made, and we get a lot of calls at our center from students with disabilities that are not getting their needs met. Unfortunately, we can usually. Why is the question? Yeah, your guess is as good as mine as to the why. I like to think that people are operating from a good place, but sometimes it makes you wonder. But certainly you have rights, and there are resources for you. And I'm glad you brought up the Disabled Student Services Office, because that's what I had forgotten to tell the last person who asked the question, is that is typically where we would want to refer people that need to request an accommodation for education.
I have a Title I question.
They're ironically the ones that gave me the hard time.
Yeah.
Does that make sense?
Not to me, it doesn't make sense. But luckily, there's recourse and there's additional resources where you can go to get advocacy and to file a complaint. Okay.
We have another question here in Spokane.
Was that Tricia or Sharon in the background that has a question?
Go.
On Title I, essential job functions, other duties as assigned. Does that fall under essential functions?
This is Mel. I don't know. I don't know the answer to that. I would have to look it up. But I do know that the ADA defines essential job functions, and then all other functions would be marginal. So I think you could make an argument that other duties as assigned, how often are those duties expected to be performed? How many other people can perform those duties? How important are they to that position? I'd have to look it up for sure, but my gut tells me that other duties as assigned is a way of saying there are going to be some marginal job duties. Even a list of job expectations on a job description may not be essential job functions. I know that. So there's definitely need to get to it. What are the essential job functions? That is so key. And I wish it was just a form that all employers had to fill out and just give them to everybody. These are the essential functions of this job. But unfortunately, it's not that clear. That's a great question.
I have a quick question. I have
Hi,
to, unfortunately,
1 second.
but is this available, is this recording available for those that aren't able to attend the full time or just the slideshow? If not, that's oh. Yeah, I just want to know, I have to leave unfortunately in 5 minutes, but I just wanted to know if this information is available to us, a recording or just the slide. And then my two-part question, and maybe I missed it, is when you're applying for a job, do you need to tell them that you have a disability? And when do you disclose that? Can you kind of wait till afterwards?
That's a Jeanette's presentation.
Well, I am gonna miss it, but
This is being recorded, so we will post it on the website.
okay, yeah, okay. You don't have to answer that right now. Yeah, so for those that didn't catch that, this presentation is being recorded. Jeanette will be addressing those topics in her presentation, which starts in a couple of minutes. And so I believe it's gonna be posted on the website. We're not exactly sure yet, but we will get the news out when we figure that out. Yeah.
Hello. I'm calling in from the Tri-Cities. Can I ask a question?
Sure, we have about 3 minutes left.
Okay. I am an employer. I hire people, but I'm also totally blind. And I have received a couple of government contracts in the past that I won, but I was unable to do those contracts because the software to run a machine to do that is not accessible to the blind. And I've been beating my head against that problem for 17 years, and no one in the government or private industries, colleges, etc., will lift a finger about correcting that problem, except the wrong finger, shall we say. What can I do? The problem still exists, and I even got a small grant one time to see if this modified software is feasible, and Battelle National Labs says, yes, this can be done, and it shouldn't be difficult. But nobody thinks there's anybody such thing as a blind machinist, and I can point out to you where there's at least 50 of them and more in the Seattle area and other parts of the country. I have a huge list of blind machinists, and we all have that same problem, that this software called CNC software is not accessible to the blind, and by ADA regulations and so on, it says it has to be, but no one, I repeat, no one anywhere, government, private, educational, so on and so forth, will lift a finger on this problem. What can I do? As you can tell, I am extremely frustrated at this issue.
Yeah, this is Mel. I would classify your question as a Title II question. Basically, what I'm hearing is you're a customer of a state or local government program. That's how I would sort of boil down this scenario. So based on that, I would direct you to talk to someone at the Department of Justice. If you want, you can.
I've tried them. They don't go anywhere with it either. I am just frustrated to no end with this issue. There's no reason why this can't be solved, and yet they don't think there's any such thing as a blind machinist, and yet I can point out hundreds of people that are in this industry who are blind, and they won't lift a finger on it. What can I do besides call these people and get a dead end again?
Yeah, it sounds like what you're hearing is people making decisions about what the capabilities are of a person with disabilities based on stereotypes. And you should have recourse for that. If you've already contacted Department of Justice and felt like you didn't go anywhere, that's unfortunate, because that's really where you have to go if you have complaints about a state or a local government. But what we can do is...
This is David Fair in Spokane. The National Industries for the Blind, they have resources for that. I mean, a lot of what they do is machining work and actual manufacturing. Just a suggestion, maybe reach out to the NIB and see if there's anything they can do to help.
I've consulted them also, and the trouble with some of the industries like Spokane and Seattle have, where they have blind machinists working for them, lots of them, they're not really machinists. They have special software that only runs a one brand of machine made in Japan, and that software allows them to push a button on a machine, and the machine does all the work. The machinist, like I am, I have to operate manually operated machines, so I turn the handles and I switch the levers and put the parts in there and inspect all the work and so on and so forth. So I'm a manual machinist and not a machinist who works for somebody such as Lighthouse for the Blind, where they do it differently by simply putting a part in a machine, and the machine is automated and does all the work. And I simply can't apply myself at a location like that. So this is still a dead-end thing for me, and I've tried to hire attorneys to sue the manufacturers and the government even about this issue, and I can't get a lawyer to take it on because they want money. They won't do it for free because they think it's too big of an issue. So here I stand.
I'm really sorry to
You know,
interrupt.
no money,
To start with
no
our next
money,
presenter.
no attorney.
We hear your cry, and we are definitely here as a resource if you do want to connect with us and talk more. There's the contact information for the Northwest NDA Center, and even DSB could jump in and work as a resource to share some resources with you. But we do have to move on to our next presenter, so I'm going to hand the mic over to.